All right, good. Good evening, ladies and gentlemen. This is a regularly scheduled meeting of the Montclair Planning Board. Notice of this meeting is posted in the lobby of the municipal building, also published in the local paper, and also posted online. We are being broadcast on Channel 34 live, and we are also streamed live on Montclair Government YouTube. This meeting is a quasi-judicial proceeding, and hopefully I can pronounce everything right tonight. And we will be exercising powers and procedures that resemble the court of law, and as such we're obligated to act objectively in determining facts and drawing conclusions that will be used to provide the basis of official action from the board. So your comments and questions to the board during these proceedings, if any, should be limited to only those issues that the board may legitimately consider, and reaching their decision in decorum appropriate for a judicial hearing is expected to be maintained at all times. First on our agenda is our roll call.
Chair Nguyen?
I'm here.
Vice Chair Brodock?
I'm here.
Mayor Spiller?
Present.
Mr. Cook is excused. Councillor Schlager?
Here.
Ms. Willis? Ms. Willis?
Oh, yes, here. I said here, yes.
Okay, I just unmuted you.
Okay.
Mr. Rooney?
Here.
Mr. Ian Wally?
Here.
Ms. Lockman?
Here.
Mr. Barr? Mr. Gilmer?
Here.
Okay. We have, just so that you know, we have Herschel Rose here tonight. Dennis Galvin cannot make it, so Herschel Rose from his firm is going to be the board attorney for this evening.
Hello, everyone.
All right, good evening.
Good evening.
Okay, next on our agenda is minutes. We have September 21st and October 5th. First to
Yes.
21st.
We had, I distributed amendments to the minutes on the 21st, and then today we received amendments prepared by Ms. Willis that have been further amended by Vice Chair Brodock and Ms. Lockman. Are there any additional changes to the minutes beyond what was sent out today?
Is there a problem with the minutes and any conflicts in what the additions were? There seemed to be some confusion as to what the subcommittee was, whether it was the subcommittee or the ad hoc committee. Did everyone agree that we had an ad hoc committee to work with the preamble? Is that agreed upon?
I think the only comment I have from Ms. Lockman is that Mr. Ian Wally she doesn't think Mr. Ian Wally was asked to comment on the preamble.
Okay, it's all on the tape. I thought that everybody was at the table. The tape has just about 10 minutes before our meeting is over. We formed an ad hoc committee of John Nguyen and Ian Wally and Daniel to be the committee that would work on that. And in fact, Daniel suggested Ms. Lockman, and she made the comment that, well, she couldn't be on the committee because Daniel and John and Tony were on the committee, and that would have made more people than a committee could hold. So I don't know if anybody else was at that same meeting. I thought that everybody was pretty much firm on that. So is that accepted as being what it is? Otherwise, we could play the tape back. It's only about three or 4 minutes, well, about 10 minutes before the meeting is over.
That may
Has to be played.
Hold on.
I just read the report. I commented on it, and Tony did not receive the preamble, so he did not comment on it. So it may
Yeah, if it's any in terms
what actually happened
practicality,
different.
I did nothing on this.
fact, it's probably my fault because I didn't actually make an effort to do anything. I got a little busy, so I had no involvement, regardless of whatever was exchanged at the meeting. So I don't think there would be a conflict if Carmel comments, because I didn't really have any activity.
Tony, you want me to remove your name from that then? This is the last paragraph. An ad hoc committee comprised of Chair Nguyen, Ms. Lockman, Mr. Ian Wally, and Mr. Gilmore was created and was authorized to draft the preamble to be presented for board discussion.
Yeah, so I think since I
So just remove your
didn't
name.
participate with that, it's probably fine. Yeah.
I'm not happy with that. I don't think we can change history. I think we can say that we would like to have a different committee from here on, but I don't think it's even ethical for us to go back and try to change history. It seems to me that at that meeting, there was something decided, that everybody took part in it, and in fact, at that meeting, Ms. Lockman did note the fact that she could not be on the committee along with 3 other people, and it was left as the committee. We can read that back. Now, at some time, if we want to say now we want a new committee, that's a whole different thing. But I really think it's unfortunate that our minutes cannot reflect what actually happened at a meeting. It's been very tedious for us to have to go back and tell the truth, as opposed to continually to put things wrong.
Carol, I agree with you. I think it should reflect what was actually said at the meeting.
That's right. That's
But what
right.
actually happened was different.
Okay. All right. I'm having real difficulty. Carmel, when you speak, I get a lot of echo. Tony, I can barely understand because there's a lot of static. Am I the only person who's having this issue?
No, I have the same issue.
So, I can't even respond to whatever you're saying because I can't understand exactly what you're saying.
All right.
I will, if someone can hear me, I will log off and try again. I'll be back on.
Yeah, Tony, your connection's is poor.
I'll leave.
And Carmel, are you dialing in on a phone or something? Do you have a double connection?
Nope. No, I don't.
Now you're okay.
When you just spoke now, you're clear.
Well, then maybe it's because Tony was on that it's causing a confusion, because I've been clear the whole time I've been on here until now that Tony joined and started talking. I have no idea, but.
Perhaps that was.
Yep.
So.
Well,
So here's the gist of it.
Chair Nguyen,
Oh,
is that it might be because Carol was unmuted at that time, and earlier we were having a little bit of trouble when Carol was unmuted and somebody else spoke. The feedback would come through kind of the echo through her speakers, and she did turn them down, but maybe with certain parties when they speak, it's just still a little too loud. So we might just have to manage that a little bit, Carol, and Janice, to maybe mute Carol when she's not speaking, but Carol certainly unmute when you have something to say.
Carol, do you know how to unmute your computer?
I just did.
No, I did that. So.
Oh, okay, because I just clicked on it maybe about the time you did.
Okay.
But I don't know that it's my speaker this time. I don't think it has been. We've been talking earlier, and it hasn't been my speaker, so I think probably it's okay.
Okay.
Yeah, I was hearing Tony and Carmel that I couldn't hear. And to respond to what Carol said, I do agree that that's what the minutes at the end of the meeting reflect, that the 3 of us were going to consult on the document. And Tony wound up not being a part of that conversation that we had at the end of last week. So whether or not he gave input to what you've seen before you, nevertheless he was a part of the committee that was going to be looking at what was going on.
I believe the issue is
When you were part of the correspondence, though, was the only, because I think, well, it's tough now. Hopefully he rejoins soon. But he was saying, the title of the document and whether we use plan, and there were correspondences via email, so I'm not sure where the disconnect may be.
I didn't get.
Set up a call. He set up a call with Janice and myself, and we spoke for Janice, maybe 30 minutes, just me, you, and Tony to align on this.
right.
So it seemed like he was part of the process, which I'm. Yeah. So, and again, if he doesn't want to be, that's fine. I just am trying to solve for the minutes reflecting reality and where we stand as of October 19th.
I believe that at that meeting, Ms. Lockman was not part of the subcommittee, this ad hoc committee.
Because we have too many.
Right. So I think just to be accurate, let's I think the minute should say the ad hoc committee was Chair Nguyen, Mr. Ian Wally, and Mr. Gilmer.
Yes, and then Janice, if it is Chair Nguyen and myself that work on this and then bring it to the board, is that fine, or is there an obligation for it to be 3, or it could be 2 people? I just want to know the parameters for
No, it doesn't matter.
a committee.
Right
Yeah,
now, we're just trying to be
Okay.
accurate.
right. Okay. I wanted it to not preclude us from making progress, basically. So, okay, that makes sense.
Okay, so do I have a motion to approve the minutes as amended?
Let's give Tony 10 minutes to come back on.
Right. Yeah.
Because
if
I
we
would like
could,
to
yeah.
hear what he, his input into this. While we wait for him to come on, maybe we can go to the next set of minutes, and we'll come back to this.
Okay. So we have the minutes from the October 5th meeting. I received comments from Keith and Carmel. Are there any amendments, further changes to the October 5th minutes? Can I have a motion to approve the minutes as amended?
So move.
A second?
Second.
All in favor?
I abstain.
Aye.
Okay.
I
Carol,
abstain.
okay. Anybody opposed? All right.
Sorry. Sorry, Janice. Your image is flickering, and your transmission, is getting some feedback. Does anybody else hear that also?
The sound is really not good.
Yeah, you've been doing a little matrix communication on
Is it
your video for me.
Is it better now? I tried closing some applications.
You're stable, clear so far.
Okay. I tried to turn off my my Outlook. I had too many things open.
The challenges of
Yeah. Okay.
I'm sorry,
I note
but
that Tony's back.
there's still feedback here. And it's still not clear, and I believe we should still work on that a little bit.
Tony, Ann, do you have any suggestions on how to address the feedback issue? I see we have Tony Ian Wally back on.
Yeah,
Ms.
how's the
Willis.
sound now?
I'm sorry, Ms. Willis, can you check your email, go to that website, and then I can help you remotely?
I'm not quite sure what you think the problem is because I don't hear any feedback. So what did you want me to do?
Please check your email.
I'd have to leave the screen and go out to do that.
That's fine. You will still be in the meeting.
Well, what he said was a little garbled from my speakers. And are you sure that it's Carol's computer? That's the issue.
I've just muted everybody. So if anybody wants to speak, you have to unmute yourself.
Yeah, Chair Nguyen, it is because if you look in the grid mode where you can see everyone, there's the person speaking lighting blue, and then Carol's lighting blue, even when Carol's not speaking. And then Carmel will speak, and Carol lights up, and then Keith speaks, and Carol lights up a little. So it's feedback through Carol when other people speak, just because you can see in grid who's lighting blue. I don't know exactly how to resolve it, though.
Yeah, this is Tony Fan. I'll be working with her, and then as soon as you check her email. So at the same time, Janice, can you just controlling the, if you want to speak, unmute yourself. Otherwise, please mute yourself, and then so the meeting can go on.
Okay.
Well, I think we need to get Carol straight before we can proceed with further discussion on the minutes or getting to our first application. So let's take the time to straighten it out now.
Okay, I see Tony's working with Carol.
Maybe while Tony is working with Carol, if the board hasn't seen Mr. Rose sent out a memorandum probably about an hour and a half ago at this point regarding one of the application 423 Bloomfield Avenue. If you haven't taken a look at it, maybe now's a good time to pull it up and give it a quick read while we're taking a short pause here.
What time was that email sent out?
I hear you, John. I'm looking for it. It was 6:13 p.m. I think it was sent to your personal email.
Yeah, I'm checking. I've got both sets up and I'm not
Are
seeing.
you there, Tony?
You hear that?
Unless it got,
I can hear John talking.
All right.
I sent the application to jtwynner@aol.com.
yeah, that's,
John, I forwarded you a new copy to your work email.
okay, great. Thank you.
Welcome.
Is it up on the screen right now?
It is.
Okay.
Do you have a microphone on? Do you have an e-plug on?
Okay, I'm speaking. Testing. I think there's still a little bit of a feedback.
I'm not hearing.
I'm asking you, Tony, is anything you're doing now going to affect?
Hi, Janice, this is Tony Dienwally. Do we have
No, I can't
Goulden's
hear what
letter?
they're saying. It's too low.
I think you're muted.
Tony, whose letter?
Goulden, he might be the attorney for the objector.
Yeah, well, what I have up is not, yeah, he,
Attorney Rose has referenced the Goulden letter. I was wondering if we have a copy of that.
no, I didn't send it out. The golden letter came in today.
Okay.
Or maybe it was sent out on Friday. I saw it today.
Would you mind making it available? Since we're sitting here, it'd be kind of fun to read.
I uploaded it.
I mean, it's either that or I have to do some homework or something.
Okay, you're calling from 400?
Tony?
Yeah.
Can you access the SharePoint drive?
Yeah.
It should be in there.
Okay, great. Thank you. Excellent.
Okay.
All right, Janice, this is Tony Fan.
Okay.
Please try it again.
Okay, so we can move ahead with our meeting. All right. I think we have everybody here, John. Where we are is we need to adopt the minutes from the September 14th meeting. September 21st, I'm sorry.
Right, and Tony, when you had to drop out of the discussion, the conversation insofar as what Carol was indicating, and I don't know whether you were able to hear all of that, but she indicated, if you're talking, Tony, I see your mouth moving, but your mic is muted.
Yeah, I mean, whatever you guys want to do is fine. Carol makes a good point. That's okay too. I was just trying to, indicate the practicality was that I didn't comment, but whatever you guys want to do is fine.
Right. All right. Well, the minutes are reflecting, what was agreed to at that meeting,
That's great.
and so that's how I think the minutes should go for vote. Anybody else have anything further to say in connection with those minutes? And if not, then I'd like to propose that they be accepted as amended.
Okay, I need a second.
Second.
Okay. I'm going to say, is there anybody opposed? If you're opposed, let me know. Anybody abstaining? So everybody else is in favor. Okay.
All right. Then that takes us to our Next,
The resolution,
resolution, right?
right. So Herschel, I mean, Herschel Rose, Mr. Rose, took all the comments that were made at the last meeting and submitted a resolution. We received additional comments. He edited it again and submitted a revised resolution this afternoon to all the board members. So at this point, are there any other changes to the resolution?
I don't really have any changes, but I do have a comment, and you know what I'm going to say, Janice. I feel like this resolution is very hard to read. And I believe that it's not necessary to go through meeting after meeting when we had the actual meetings, we have a recording of the meetings, we have minutes of the meetings, and then we now have a recap of all the meetings in this resolution. And to be perfectly honest, I feel it's incumbent on somebody looking and voting on a resolution to go back and make sure that everything is accurate. From every hearing that we were at, I feel like if you're going to approve a resolution or say no to it, you need to understand exactly and make sure that there's no errors in the resolution. And I feel like it's very cumbersome to ask board members to go back and look at however many hearings we had on this to feel confident that what's in the resolution is accurate. So therefore, I feel like there should just be a summary statement of what went on over time in a condensed format that leads us to the conclusion, whatever the conclusion of the resolution is. And I understand that's not the practice of this particular law firm, but other law firms do it that way. So in my view, I would encourage this law firm to not go meeting by meeting, witness by witness, basically rehashing the testimony that is recorded, that's also in contemporaneous minutes. So I would just want to go on record as stating my objection to the way that it was written. If you want to call it an objection, just my thoughts on this.
All right, any other discussion? Then I would move that we accept the resolution as it's in its final form as it's drafted.
Is there a second?
Second,
Robin, okay.
yes.
All right, I'm going to do the roll call for this one. Chair Nguyen,
Yes.
Vice Chair Brodock,
Yes.
Yes.
Counselor Schlager,
Yes.
Mr. Rooney,
Yes.
and Mr. Barr is not here. So I believe those are the only ones who are eligible to vote.
Janice, you can call my name and my answer is abstain. Thank you.
Okay. Okay.
All right, and that brings us to the application on 423 Bloomfield Avenue Properties.
All right. We have here, I have to.
Uh-oh.
Alan, are you, can you hear me? Mr. Trembulac? I tried to make you a panelist so you can speak. I don't see him.
I see him listed as panelist. I just don't hear him.
Alan, you need to turn on your speaker, your microphone. And I assume that Paul Sionis, I made you a panelist as well, so you should be able to speak, Paul. And let me know if there's anybody else that I need to bring in for this. I understand Mr. Jonathan Golden is one of our call-in users. Paul? Can you turn on your audio? Or Alan?
Doesn't look like Mr. Sionis is connected to audio, but it looks like Mr. Trembulak is now.
Alan, you should be able to speak.
Can you hear me?
Yes.
Oh, good. Well, I'm having trouble with the video, but at least I've got the audio now.
Okay, Paul, I think you should be able to speak too.
I think I'm on now.
Okay.
Good.
Is there anybody else I need to bring in for your presentation?
I don't think so. Scott Kennedy should be out there, but.
Is he going to speak tonight?
Not intending to call him as a witness unless there's.
Okay, then I can make him, if you want him to speak at that time, let me know and I can make him a panelist. But for now, I think we have everybody that we need here.
Okay. Okay, so are we ready then?
Yeah, I'm going to mute myself and
I think that was the handoff to you, Chair Wen.
yeah, Alan, go ahead, or John, go ahead. You can make your presentation.
Yeah, Mr. Tremulette, the floor is yours.
Okay. See, I've successfully connected by video also, so everyone can hear me?
Yes.
Okay.
Yes.
All right. Good evening, Mr. Chair, members of the board. Just for the record, Alan Tremulak appearing on behalf of the applicant, 423 Bloomfield Ave Properties, LLC. This is a continuation of the hearing which commenced at the September 14, 2020 meeting. Since that last meeting, we've submitted revised plans prepared by Mr. Sionis to address some of the comments and concerns expressed by the board members as well as by the attorney for the adjoining property owner. So what I'd like to do this evening is to just present some additional testimony from Mr. Sionis to review the plan revisions with the board. And that I believe would complete our case, and then we would be prepared to go to deliberation and summations and hopefully conclude the matter. So if I may, I'd like to recall Paul Sionis.
Okay. I'll swear Mr. Sionis. Mr. Sionis, would you raise your right hand? You swear affirm the testimony about to give in this matter is the truth, whole truth, and nothing but the truth?
Yes, I do.
And you were qualified at the last meeting by the board?
Yes, I was.
The board accept the qualifications?
Yes, they did.
Okay.
Okay. Go ahead, Alan.
All right, Paul, you prepared revised plans subsequent to the last planning board meeting, correct?
That's correct.
All right, and have you prepared a PowerPoint to utilize with your testimony this evening in discussing those plan revisions with the board?
Yes, I did.
All right, and I believe a copy of that's been submitted?
Yes.
Okay. I believe we probably need to mark that, Janice, as an exhibit. According to my notes, it would be A15, I think.
Just give me a minute. Let me, no, that'll be A16.
Okay. Janice, do you have a what is A15 if you have that there?
The HPC report dated 8/27/20.
Thank you. All right. Well, you have the PowerPoint on the screen now?
Yes, it is. It's on the screen.
Okay. Do you want to walk the board through the various plan revisions that you made?
Sure. And Janice, I will ask you to, as always, I'll ask you to turn the page when appropriate.
Got it.
All right. So after the last meeting, we made revisions to the drawings and revisions to the PowerPoint based on comments and questions from the planning board members. And the first page of this PowerPoint dated October 19, 2020. All of the 14 pages of this revision are dated October 19, 2020. So the first page has a list of the changes, and this list was submitted to the planning department and also is on the planning memo from Janice Talley dated October 14, 2020. So I will walk through some of these changes and revisions. Some of the slides are a little bit redundant, but I just want to emphasize some of the revisions that were made based on the questions and comments. So basically the changes included, we added an additional light fixture, and I'm looking at the middle right side of the PowerPoint in that chart. We added an additional light fixture on the south side of the existing second floor apartment on the subject property. We updated the site plan to reflect existing conditions. On drawing A101, we also updated the second floor plan based on existing conditions. A102, same thing, third floor plan and roof plan were adjusted based on existing conditions. A103, the cross section was adjusted based on existing conditions. And what I mean by existing conditions, and I'll walk through this, is there were questions about the neighbor's windows, the neighbor's easterly windows on the east side of 425 Bloomfield Avenue. So I sent a staff member to go back and verify the exact locations of the windows in the neighbor's easterly wall. And that was done, and that's reflected in these drawings. The drawing A104, some of the elevations were updated. There were questions that the chair asked about the material on the box bay window, and we've answered that in this PowerPoint. A105, we added an additional privacy wall on one of the balconies on the north side of the elevation. A107 shows that updated privacy wall, a brick screen wall, and then the two existing conditions drawings were updated based on the exact measurements of the windows in the neighboring building. So if we could go to slide number 2, please. So slide number 2, as I stated, I sent one of our staff members, one of the architects in the office, went back up to the roof of 423, and we asked him to verify the exact location of the windows on 425 Bloomfield Avenue, which is the adjoining neighbor directly to the west. He checked it both from the front and the rear. We asked him to go back and check it again, and he did. So we have the exact location of the windows, and then the vertical orange line shown on here on this slide number 2 indicates the south edge of the proposed addition, the second floor and third floor addition for 423 Bloomfield Avenue. Next slide, please. And again, just to repeat, we're not blocking any of the windows. We're not building in front of the windows or covering the windows. So we've adjusted the footprint on this slide number 3. We've adjusted the footprint of the proposed addition to step in away from the windows further than it did previously. Next slide, number 4, please. This slide again shows that we've revised the floor plan so that the south wall of the new addition steps further away from the neighbor's windows. So the wall, the closest point of the wall is now about 8 feet 1 inches compared to last month. It was only 3 feet 1 inches from the neighbor's westerly wall to the jog in the wall of 423 Bloomfield Avenue. Previously, we had a box bay window, and I'll talk about that a little further, within this oval area that stuck out or protruded to the south as much as the box bay and the bottom of this floor plan. That's been eliminated to make sure we don't block light into the windows of the adjoining building. We've also, as I stated, the other oval in the top right of this floor plan, the oval that I drew, thank you, that shows we've extended a perforated brick screen wall for privacy when someone's standing on the second floor terrace. And I'll have more drawings of that. So next slide, please. Slide number 5 are the 2 upper floors. The upper floor levels were also revised to show the increased jog on the wall to keep this further away from that window on the neighbor's westerly wall. Next slide, please. Mr. Wynn, the chair, had some good questions last month about the way the glass doors, the glass terrace doors and the railing were rendered. And in the last PowerPoint, it looked like it was a solid railing at the bottom part of these glass doors. So the drawing was corrected, the rendering was corrected so that you could actually see the glass through the balcony railings. And this is how it is meant to be, that these will be metal railings, maximum 4 inches on center horizontally, and you will see the glass through the railings. And then we've also, there was questions about the cladding of the box bays. The box bays are these box projections with windows that come out a bit from the brick facade of the building. And Mr. Wynn asked, where can you see that? What do these really look like? So if we go to the next slide, number 7. Slide number 7 shows some examples of the same cladding. The slide on the right is the shade store on Bloomfield Avenue. This uses a similar aluminum composite cladding. This facade just won an award from the Montclair Historic Commission for the facade renovation. It's pretty attractive and low key. And then the building on the left is an image of a building. It says it's in Brooklyn, but it's actually in Astoria, Queens. And this uses that same aluminum composite material. The building on the left, the entire building was aluminum composite cladding, but I think it's a nice touch when it's used as a contrast or against the brick walls like we have on 423 Bloomfield Avenue. And I need to point out that when we appeared at the Montclair Historic Preservation Commission, our facade was slightly different originally. We had it more traditional in appearance, and we were specifically asked by the Historic Commission to make it more, as they said, of this time and not falsely historic. So items that we had that were more cast stone or round top windows, those were changed to the facades that you see tonight. So next slide, please. Slide number 8, this shows the south elevation. And as I mentioned last time, this elevation, the new part of the elevation, the upper floors, would not be visible from the sidewalks on Bloomfield Avenue. Definitely not the north sidewalk or the south sidewalk from a pedestrian standing on the sidewalk. This would be visible from the upper floors of a building, but not from the sidewalk level. So as this shows, is that we've redone that south wall of this building so that the new addition steps in as it approaches the westerly neighbor's wall. So as you can see in shadow on the left side of that brick, that the wall steps back to not block light or intrude upon the windows. And you can see on this facade, the south facade, we're using that same aluminum composite box bay on the east side or the right side of the facade. Originally, we had a second box bay to the left of this or to the west, but we eliminated that because it stuck out further to the south, and someone in the building to the left, 425, would have seen the side of that box bay. So that's been eliminated. Slide number 9, please. Slide number 9. This is the south elevation as seen if you were standing on the roof deck. So as I mentioned, there's an existing apartment at the front of 423 Bloomfield Avenue. It's an existing second floor apartment. And the proposal is to install French doors, as shown in the bottom right image, install French doors at the rear or north side of that apartment to access the flat roof and have a roof deck there. So the view on the left is the view as would be seen from the apartment, the existing apartment at 423 Bloomfield Avenue. Again, you see how the wall continually steps back as it gets closer to the building at 425 Bloomfield Avenue. And then the image on the right, labeled number 9, that's the north elevation of the existing apartment. And again, it's proposing new French doors to replace windows that would access a roof deck. And then there were questions about the lighting at the last meeting. Those are the two, flanking those French doors are the two lights that have been added to the light fixture schedule. And those would be what are known as barn lights. They're wall sconces that get attached to the wall. They have a circular base, and the light faces down and does not spread very much horizontally. So the concern last time was, would these lights shine into the office space that's on the second floor of 425 Bloomfield Avenue? And my opinion is that they will not, since they will be shielded to point down. Next slide, please. Slide number 10. This describes the perforated brick screen wall that's been added since the last meeting. So the top left is the east elevation. This is the view that possibly could be seen from the future parking deck, but probably not. And circled with the orange oval, this perforated brick screen wall that would be added to that second floor terrace. And the image on the right is an enlargement of that, showing what I mean by perforated, in that bricks would be removed from that wall to let light in. So it wouldn't be obtrusive like a solid brick wall would be, but this is just on the westerly side of that terrace on the second floor, the terrace for the ground floor of the proposed residence. Slide 11, please. Slide 11, this is an updated cross-section. Again, as I stated, the staff member went out and measured those windows, the westerly windows, as access from the flat roof. So this is the exact location of the existing windows. Excuse me. Next slide, number 12, please. Slide 12 is an updated 3D rendering. This is the proposed exterior elevations inserted into an actual photograph of the site with the surrounding properties. This has been updated for the box bays. The glass, the window frames are, the color is black. In the previous rendering, it was, I think, brown or beige. And the next slide, slide number 13. This is the context view that shows this is the rendering of the future parking deck on Glenridge Avenue that the township provided us with a copy of, and it has the proposed improvements to the north side of 423 Bloomfield Avenue, shown in context to the surrounding properties. Again, if you recall, the existing building was covered with stucco, probably around 1980. The stucco is there, and the proposal is to remove the stucco from the rear elevation and replace it with this cast stone and brick in addition to the box bays. The ground floor is in the location where the ground floor and the first floor is in the location where it currently is, but the additions step back as it goes up vertically, steps back further from that northerly property line. Next slide, please, 14. So this is just a recap from last meeting. There are a couple of variances that were requested as part of this application. First was for a rear yard setback So the requirement in the C1 zone is for a 10-foot rear yard setback. The existing building has an existing setback of 2.1 feet. We're matching that existing condition of 2.1 feet, but as the building goes up vertically in height, we're stepping it further away from that northerly property line. The second is that there was a variance requested for a wall sign. We're proposing one plaque, basically a bronze plaque on the north elevation adjoining the existing entry doors. However, a variance is required because the signs shall not extend beyond the portion of the building occupied by the reference business. The reference business or businesses are on the main floor of the building. The rear entry is at a lower level, so a variance is requested for that. As I stated, most customers to this building currently park in the Midtown parking lot or on Glenridge Avenue, and many of them use this rear entrance. So a small wall plaque would provide wayfinding so people know how to get to the business. Third variance is for parking. We discussed this quite a bit last month. 2 parking spaces are required for one 3-bedroom apartment, and no spaces are provided. As we discussed, the applicant obtained an agreement from Montclair Parking. There's a copy of his agreement attached to this slide. The agreement says that Montclair Parking shall provide 2 parking spaces on an ongoing basis in one of its parking lots in the vicinity of 423 Bloomfield Avenue. So the applicant's not saying we're just going to park on the street. They made an effort to provide parking based on this agreement they've reached. The property is covered by the footprint of the building, of the existing building, which prevents providing on-site parking. And I don't recall if I got to make the planning arguments, but the variance can be granted on a C1 hardship zoning analysis, which states that the shape of the property and the lawfully existing structure are what causes the hardship. The shape of the lot, the location of the existing structure make it impossible to construct additional parking without removal of the existing building, and thus that causes the hardship related to the land that justifies the parking variance. What we learned when we went to the Historic Commission is that this building was constructed prior to 1898. We found a photo from Montclair Public Library of a parade of soldiers marching down Bloomfield Avenue on their way to the docks on the way to Cuba for the Spanish-American War. And this building was there, as was 425 Bloomfield Avenue. So building's been here a long time with this parking arrangement. We discussed also last time, what's the benefit to the public of this application? Does it just benefit the applicant? Well, I thought about that since the last meeting, and the public benefits from the fact that the applicant is somebody who loves the building and wants to significantly improve it. The township should actually want everybody to do that with their buildings, that is, to invest in their properties. And the benefits of these exterior improvements outweigh the detriment of the 2 parking spaces that they're short with the addition. And then finally, this is a permitted use in the C1 zone. We're allowed to have a 6-story building on this site. This is less than 6 stories. We're complying with the allowable density. And then finally, we're not building in front of neighbors' windows. In the town I grew up in, it seemed like everybody built new buildings in front of the neighbors' windows just because the windows were on the property line. This is an applicant who's stepping in his addition to avoid the windows. He doesn't have to. It's a nice gesture, but he's doing it. So that basically concludes my description of the revisions. Thank you.
Thank you, Paul. No further questions, Mr. Chairman.
Mr. Tremulak, is this the only witness that you'll be presenting to speak about the arrangement with the parking authority?
You mean, well, it's not with the parking. No, Mr. Kennedy, I believe we introduced the letter from Montclair Parking, which operates several private parking lots in the downtown. And the commitment is that they would provide 2 parking spaces to the applicant in one of these private lots. And the applicant is committing to obtain those parking rights and to maintain them so that he would always have parking available for the 2 cars in private lots without utilizing any of the existing public parking resources in the downtown, whether it be on street parking or in the parking lot or parking deck to be constructed.
So what happens when those private parking lots go away? Then what?
Well, then the applicant or the owner of this property will have to find parking. And if that means,
Well, definitely, but what will it do to the, in terms of if we were to grant this application based on your representation, this is not an in perpetuity kind of arrangement that we have here, but the parking theoretically, very well could be, unless, cars go away. I don't think in my lifetime or yours or my children's lifetime that's going to happen.
well,
and the idea behind having a parking requirement for a property so that you can have a place to park the vehicles for the residents of the property. And so this addresses the near future. I guess, I mean, the letter's kind of vague. It doesn't have a term. It doesn't have, it's not in the nature of a contractual commitment. I don't know. I might be wrong. Maybe it could be enforced. It would certainly be one of those things that could be questioned. But again, just trying to understand, how the perspective that we're supposed to perceive this representation, in that, this is a private parking facilities, and, knowing where these facilities are located, it's not inconceivable that those private lots will go away and be developed with other buildings.
that's true, Mr. Chairman. I think the important point to me that I like to make is that's a risk to the property owner. If those existing lots are no longer available, then the property owner that's got 2 cars has a problem. It's the property owner's problem, and he or she or it, whoever it might be at any given point in time, is going to have to broaden the area if necessary. Maybe, there's lots of properties in town, older commercial properties that have garages in the back, or you have other privately owned properties that have parking lots, parking garages. The applicant, the person living in the building, which in the immediate future will be the applicant, if they've got 2 cars, as my clients do, they've got to find 2 parking spaces. And if these lots go away, that are in the immediate area, whose problem is that? The burden of that doesn't fall.
Isn't it
upon the town?
Isn't it part of the town's problem? I mean, that's why we have parking requirements, so that cars can be parked in a manageable way in our commercial district, and that cars with development, extra cars don't become a burden to the town and to the residents of the town that, are not able to then conveniently park their cars for shopping and other activities that go on in the commercial district. That's why we have these laws enacted on the books. So, the laws are enacted as a result of the police power. It's the town's problem. Yes, it goes without saying that the resident is going to have to find some place to put their cars. But the idea is that they put their cars where it's not a burden to the community, right?
Well, right. And this would be lots where they would have to really have access 24 hours a day with overnight parking. They couldn't park on the street. We're committing not to park in public facilities, even though I think we have as much a right to do that as anyone else. But if the applicant, or I should say, if the property owner has 2 cars, the property owner is going to have to find 2 parking spaces in some private lot.
And what happens if he chooses to park on the street and ignore all that?
He can, there's nothing anybody can do that can prevent the applicant or anyone else from parking on the street during daytime hours when parking is permitted. But the point is, if they own 2 cars, they've got to have a place to put them 24/7, and they can't do that on public property. I don't know what more my client can do other than commit to, maintain 2 parking spaces in a private lot, and for that requirement to go on in perpetuity, actually. And
what happens if, what I'm asking, Mr. Tremulak, is what happens if they default on that commitment? What's the town's recourse?
The town, whatever.
I don't think the town has a recourse. That's my problem.
Well, I would.
I'd be able to step in here for a second.
Please do.
We could make a condition of approval, if this were to be approved, that the applicant commits to maintaining the parking spots and will submit on a maybe annual basis to the board proof that the agreement is still in effect, or something to that degree.
But the board is not going to police this. It would have to be to the town. And what can the town do if they blow off that commitment?
If they're not complying with the continuing terms of the resolution, they would have zoning compliance.
Tony?
I'd like to ask a question about the Paul Sionis's testimony that the variance, regardless of whether or not the owner rents a parking space, there is testimony being given that that a variance can be granted based on a C1 zoning analysis, and that it complies. So whether or not there's parking, it seems like this variance
complies with everything, though. So,
what?
The testimony, Mr. Sionis's testimony, is that it complies on several aspects, even with this. So, I mean,
yeah. So that's on the table. Attorney Rose, what do you think of that assessment, regardless of whether or not there's rental parking someplace else? Because I look at that as a separate matter. I mean, if let's say there were no parking available and the applicant did not present this Montclair parking arrangement, is it a true hardship, and should it be granted just on the basis of the hardship?
Well, that's something the board will have to consider, whether there's a true hardship.
What's your advice? Do you have advice to us on that?
Yes, the hardship traditionally comes from the shape of the property and the structure as it is on the property, and
there's nothing
so the fact that there is no place to put a parking space is a hardship. Therefore, it may be granted according to municipal land use law. Is that the that's what's on the table right now?
That's what
in terms of the planning testimony.
I'm not sure I agree with that 100%.
Okay.
I wasn't here for the last meeting. I reviewed the minutes, but I don't know if there's a possibility that parking could be installed on this property or not.
So, Tony, from our standpoint, from the board standpoint, the argument is that exactly what you said. That's the argument, that because of the shape of the property, they're expanding the property, that if there's a hardship that forbids them from expanding the property. But the flip side of that coin is that they don't have to expand the property and cause the hardship. They can leave the property just as it is. And as Mr. Sionis has pointed out, it's been functioning that way for 100 and some odd years. And it's, been perfectly fine. So, that's the question that you're asking of our attorney really isn't fair to ask of him, because that's the kind of decision that the board has to make based on whether we accept certain facts and whether we accept certain premises, with respect to what the law provides.
Thank you.
It's a determination that we have to make.
That's correct, yes.
All right, well, I don't want to beat a dead horse. I'm just trying to understand, again, where parking is going to be and this is not a focus, Mr. Tremulak, on your client per se, but it's the result of years of granting parking variances. And, you know, we can't, obviously, I don't think we can continue to do that without giving serious examination to each and every application that comes up, because right now we're waiting on information. We have no idea exactly how burdened the parking garages are going to be when all the new construction is completed and everything is populated and everything is in full use. But we know, we've been listening to arguments that have been saying that, yeah, we're going to get parking, we're going to get alternative parking, we're going to get alternative parking. But the town doesn't have a mechanism to enforce, you know, these promises. And there isn't really even a contract with the Montclair parking. And Montclair parking changes hands. Let's say they don't even go away. The owners change hands. I mean, it's conceivable that they could say, you know what, we're not going to do business with you, with the applicants, you know. And so we're just looking forward to try and find just how secure this promise is and just exactly what it does for the application.
Well, I would just make the following comments. Sir, what Mr. Rose suggested, I think, is something that I offered at the last meeting, you know, an annual certification of some kind to confirm that the applicant or the property owner has agreement in place, identifying the location to park 2 cars. And in terms of enforcement, this is rather dramatic. However, the board ultimately could revoke the certificate of occupancy for this apartment if that's not complied with. I have no problem with that, because the reality, Mr. Chairman, as I've said several times, is no one has a greater interest in parking 2 vehicles more than, you know, the applicant, the property owner itself, whether that's today or 20 years down the road when the Kennedys sell this property.
When it becomes a rental unit, I agree with you. When the owner applicant is living in there, yes, I agree. When this becomes a rental unit, which it probably will become a rental unit at some point in time, you know, I'm not sure.
I understand that, Mr. Chairman, but the point's the same, though. If I'm a prospective tenant and I'm interested in renting this, my first comment to the landlord is, where am I going to park my cars? And the landlord's got to have an answer to that, or he won't be able to rent it. No one's going to rent it if they've got 1, 2, 3 cars without being able to park those cars. So the landlord's going to have to tell a tenant where parking is available, or the tenant is going to have to secure that parking, or they're not going to rent the space. You know, and that's true with every subsequent owner or tenant that's interested in this property. I got to park 2 cars. Where am I going to park them? And if these lots nearby are no longer there, well, it might get harder. And you might have to expand the territory, and you might have to walk a half a mile to some location that's not close by in order to park your cars. You know, the fact is, no one will be able to rely upon public parking to satisfy the need to park 2 cars, because the cars would have to be parked overnight, and parking's not available on the street. 24-hour permits are available, at least currently. But again, we're committing not to utilize public parking facilities. So, you know, people might have to walk. People might have to Uber to, you know, a mile away to get to their cars, if that's necessary. But they're it's the property owner, it's the occupant that's bearing the risk, not the town, in my view. We're not going to be able to rely upon public parking facilities to park these 2 cars overnight, 7 days a week.
Okay.
We're willing to agree to-
I understand what you're saying, Mr. Tremulak, although I don't agree with your last premise that it's not the town, because if it wasn't the town, we wouldn't be able to enact legislation to regulate it, as part of the police power.
No, but what I'm trying to say is the detriment of not providing the parking is not going to be a detriment to the town, but rather a detriment to the property owner who can't park his cars or maybe has to park them in Verona if it gets to the point where there's nothing available in Montclair. So I'm just repeating the same thing over and over again, Mr. Chair. I apologize for that.
It's okay. That's okay. Does anybody else on the board have any questions that they'd like to direct at Mr. Simons?
Yes. So I think we may have covered this at the last meeting, but just to make sure, well, I guess it's two quick questions. One, there's no real way to ensure this condition follows for the next owners. That's what you're getting at, Chairman, is that right?
Well, that's a possibility to make it something that, has some teeth to it. And, as to whether it could be a condition of a deed, I think we have had that discussion. But it's not, but the idea is that whatever kind of commitment that there is, it's a lasting commitment, and that we have some recourse if somebody chooses not to honor it.
And just, not to interrupt, I apologize, Mr. Gilmore, but that issue was raised at the last meeting, and Mr. Galvin, I believe, even advised the board that you could require a deed restriction, and I certainly have no objection to memorializing this in a deed restriction, so it's part of the public record, and anyone purchasing this property in the future would be on notice to that requirement and would have the obligation to continue to comply with it. So.
Yeah, so it was discussed, and I had heard that covered. I just didn't know if we had finalized the consensus that actually would be a condition, or if we've not gotten a final consensus on that.
We haven't discussed conditions, but Mr. Tremulak did indicate that would be something that the applicant would be agreeable to, as I said.
Right, and then Mr. Tremulak, just so I understand and I'm following this, if it's a burden to the applicant, not for the town, I'm not totally clear why it's listed as a comment under 3, where we say the variance requested from Montclair Code. Why is this even mentioned if it's not a concern for the town to take into play?
Well, it's a concern of this board. I mean, we need a variance. So, I mean, because the zoning ordinance requires 2 parking spaces, we can't provide them. So in order for this application to be approved, the board would have to grant that variance. So,
right, okay, that was my reading.
I wasn't suggesting that it's none of the board's business. It certainly is. I was just suggesting that the inability to provide the parking would result in a significant hardship or detriment to the property owner or the tenant or whoever is occupying the apartment, more so than the burden falling on the town or township parking resources.
Yeah, and I gather the rationale of the hardship given the existing condition. I think what I'm wrestling with is, does this exacerbate the current circumstance such that the issue around parking is even worse than the current state is? But okay, I think we really hammered that piece down, so thank you.
Thank you.
Other questions from the board?
Yeah, I have.
I think I've got it.
Oh,
go ahead.
I just had, who is Montclair Parking? Just, a developer who owns an empty lot or something?
Well, I can answer that because I've seen their signs in various locations, including the parking lot behind my building during times when there were events being held at the Wellmont. I believe it's an entity that Stephen Plopker has an interest in because they operate several lots, again, on North Willow Street behind my building at the corner of 363 Bloomfield Avenue. They also operate the parking lot that's adjacent to the new Chase branch building on North Fullerton. And I believe, well, this one's not going to be there for long, I don't think, but they have operated, and I think they continue to operate today, the parking lot at 65 Church Street that I'll still refer to as the Haynes parking lot, since I've been in town so long. But you know the lot I'm talking about, and I know the board has an application pending, but they operate that lot and one or two others.
So to Mr. Nguyen's point, Montclair Parking is not a company that's in the business of owning and operating parking lots. It's really in the business of developing and has some property that they're, holding until they get to the point where they're ready to develop the property. So inevitably, if we're looking forward, this will be a shrinking availability of parking as these areas become developed. Would that be a correct?
Well, it's a separate entity. It's not a developer or a property owner. The name of the business is Montclair Parking because they operate these various parking lots.
Yeah, I think we know what we're talking about.
Yeah.
The second point is, grant the variance, isn't it? It's kind of incumbent upon the town to police those two cars to make sure that they're not parking in spaces that would otherwise be available to the public. And that seems very impractical.
Well, I don't know what to say. Then there would have to be a permanent home for these vehicles because you can't park on the street, overnight anywhere in Montclair with some exceptions. So, I mean, can we say that one of these vehicles can't go out and drive to another part of town and park at a parking meter on the street? Of course, there's no way to police that. We're talking about a permanent garage, if you will, in quotes, for these cars to be stored 24/7 when they're not in use.
That's all I have.
Tony, did you have a question?
I have comments, no questions.
Any other questions from the board members?
Yes. So one question on the, and maybe this is to Mr. Sionis, but one question related to why the variance can be granted on the C1 zoning analysis. I assume you mean the C1 variance, that it's a hardship. Wouldn't that really count for all the buildings in the commercial business district?
Correct. That would count for all of the buildings that are totally landlocked, that cover all of the land, all of the property.
So in essence, because I've heard in some of these planning board meetings that, there's a reason why folks can't build the 6 stories in this district, and it's because you can't park it. So I think what you're saying is that if, we extend this logic out to other properties, that as long as somebody can secure private parking, they'd be able to apply for, this type of variance. And if the board grants it here, it would presume that the board would grant it elsewhere.
Well, again, each application stands on its own merit. So each application would have to be heard individually.
And my other question is, what was the idea behind putting a kind of a accessible rooftop terrace for, I think, the existing apartment, kind of right up against the windows of the adjacent property? It seems like it's an area that's not currently used, but now we're making it or you're asking to make it a usable space right next to other windows. It just seems a little strange to me.
Right. So that currently is a flat roof that's not used except to collect rainwater. So the point was to create an amenity for the existing apartment that faces Bloomfield Avenue by replacing the windows with French doors onto this roof. And as was stated at the last meeting, those windows on the roof for 425 are an office. It's not an apartment. Really, the bigger impact would be to the windows in the applicant's own addition, because there's a bedroom window that faces onto this roof deck. We've talked about, he would have to have window treatment on those windows in his own building. So the point was just to provide an amenity for the existing apartment.
And I think that makes sense. It just seems strange to put that right up against an adjoining property's windows. And I get that there are different uses, apartment and office, but the apartment dweller could be there at any time and folks in the office might be there till 8 o'clock at night. I don't know. It seems like they could cross over pretty easily.
Yeah, we've actually discussed the idea of planters on the rooftop as one solution to that.
Does that then block the light from the adjoining property's windows?
No, it would just provide privacy. They would not be up against the windows, but they'd have to be placed carefully to provide some type of screening, but not block light.
So is that something you're proposing here tonight?
We can. We've discussed it in the last week, considering the privacy aspect of having this roof deck right next to 3 sets of windows, the existing apartment in the front, the 2 windows for the office in the adjoining property, plus the windows in the applicant's addition. I think if it was planters with deciduous plant material, so it would provide a screen during the warmer weather. In the winter, people would not be on that roof deck, presumably.
Would you be able to show us on one of these slides where you'd propose to put those planters?
Janice, could you go back to slide number 2, please? Yeah, slide number 2 shows the 2 windows on the bottom left of that photograph that are part of office space in the adjoining building. I believe that if we had planters maybe 4 feet out from those with deciduous planting that's maybe 5 feet tall, it would still not block any light, but might provide some privacy, both to the users of the roof deck and to the office users.
Could you just switch to a plan view?
Okay.
Just so I can see that.
Let's go to slide number 4, please. So slide number 4.
So here,
yes.
Is it the first kind of bump out, we'll call it, away from the adjoining windows? That is, what, 8 feet away, roughly?
Correct. So if it was partially between that bump out and the neighbor's building to the west.
Okay, so does that end up covering up that block window of the existing apartment?
Let's look at.
It's like a frosted glass. It looked like on the photos.
Yeah, I'm sorry, Janice. Slide number 9, please. It's glass block in the bottom right.
Yeah.
Yeah. I don't think that would be a detriment to block that or to have a planter partially in front of that.
Okay, that's all I had.
Thanks for the questions.
I have a question. It's Robin. Janice, could you go to slide 13? So on this slide, at the bottom of the proposed new building, there are 2 cars parked there.
Correct.
Wait, whose parking spots are those? What is that?
Those belong to 425 Bloomfield Avenue, the neighbor to the west.
So those are their parking spaces?
Correct.
Okay. So the applicant of this does the applicant of this building have allotted parking spaces to them for their building?
No.
No?
Those spaces, the only cars that can park in the area that's shown on the plans or anywhere behind the building would be cars or 425 Bloomfield Avenue, the adjacent property, not this property. This would be a much simpler application if my client could park there, but we can't. It's the easement area which allows us to access, but it also provides parking for the adjacent property owner, but not us.
Okay. Okay. All right, that's a little confusing to me that they have, their building comes with 2 parking spaces, I guess. Is that? Okay. Okay, thank you.
I think part of it is the shape of the property too, is irregular. So that's why there's an easement involved, and that's their property.
Okay,
Yeah.
okay, thank you.
Any other questions from the board? If there are no questions from the board, what about our general public attendees? Is there anyone who would like to ask a question of Mr. Sionis about what he talked about this evening? Let Janice know.
I'm in the process of unmuting the attendees. So hold on a minute. It's very slow. Okay. Mr. Restaino, do you have any comments?
Questions?
Questions, I should say. You have to turn your audio on. All of you who are attendees, if you take this opportunity to turn your audio on, I'm going to unmute you one by one. So Mr. Mark Restaino, right now, you're unmuted. He says his audio is on. Tony, I've unmuted him. We can't hear them.
Right, so the other option is to submit questions to the chat function to Janice.
Okay, I can, yes, Mr. Restaino, I can see that you've sent you sent me a message on chat. If you can't get your audio to work, I can read your message on chat. Yes, I can read it, Mark. He says, hello to everyone, Mr. Restaino. He's a tenant at 423 Bloomfield Avenue, the 2nd floor apartment. Mr. Restaino.
Is that a residential or a commercial tenant?
Hold on. We just wanted to say that Scott and Pilar are wonderful landlords and they really do want to make the building a better place for the town. It's residential. Okay, so Mr. Restaino has a comment. Do you have any questions?
And if he has a comment, then we can hold his comment for the next.
Okay, Mr. Restaino says he has no questions at this time.
Okay.
So I'm going to mute Mr. Restaino. The next name on my list is Daniel Garcia Pedrosa. And it appears that, Tony, I'm not able to unmute him. Mr. Pedrosa? I mean, he says he has a comment. He has a comment.
Yeah, that's connected to the audio.
Okay, I'm going down. I'm going to continue down the list. He has a comment. I have call-in user at the number 973-868. Do you have any questions for Mr. Sionis? I think we believe we've unmuted you. Tony, is he unmuted? 973-868?
Janice?
Yes.
You know what? I think that's my phone. When I was having trouble earlier, I wanted to, I connected my audio with the phone. So that's probably what you're seeing.
Okay, then I know the next number we have, which is call-in user number 3, which is 551-580. I believe it's Ms. Jonathan Golden.
Hi, Janice. Yes, I don't know if you can hear me, but I don't have any questions.
I do hear you. Okay, he has no questions.
Okay. That's it, right?
That's it.
Okay. All right, Mr. Tremulek, anything further?
No further testimony, Mr. Chairman. That would conclude the applicant's case.
Okay. So if there are members of the public who would like to comment on the application, now's the time to do it. And if there are problems with the phone, you can type your comments to Janice and she can read them for us.
Okay. Mr. Golden, I believe you're still unmuted. Do you have a comment you want to make?
I do. Thank you, Ms. Talley. So again, it's Jonathan Goulden, Guldin, with the law firm of Clark Goulden Attorneys at Law at 20 Church Street. I represent DSV Associates LLC, which is the owner of the adjacent property at 425 Bloomfield Avenue. Before I get to the crux of the objections my client has to the application, I just wanted to address the roof deck that Mr. Brodock was addressing earlier. To the extent that the applicant's application were acted upon favorably, we would ask that a condition of any approval be some sort of screening, at least 4 feet, if not more, along those windows. They were prior office spaces, those 2 windows above the existing roof deck. The intent, however, is to make those residential, and to have a roof deck immediately outside of those 2 windows, my client feels would be problematic. So we would ask that the condition of the planters or deciduous trees that were being discussed be included as part of any approval. Getting to the crux of the issues my client has, Ms. Talley, could you turn to slide 3 of the PowerPoint? So slide 3, if we're there, I think I'm on a bit of a delay, shows the easement area in gray. This is the area that Ms. Schlager was just asking about, where the cars are parked. That area is owned by my client, 425 Bloomfield Avenue, and that is the subject of this 1994 easement that was entered into between the predecessors of 423 and 425 Bloomfield Avenue. And I think a lot of the issues regarding parking also are somewhat related to the problem here, which is that, as you can see from that drawing, the egress and ingress into 423 Bloomfield Avenue is through a doorway that protrudes over the 423 Bloomfield property line into my client's property, and you cannot enter or exit that building without traversing over and through that easement area, again, area that is owned by my client. In the correspondence that we submitted to Mr. Galvin's office today, and that's referenced in the memorandum that Mr. Rose circulated earlier today to the board, we point out that that easement in 1994 was expressly for the business purpose use. That's the language utilized in the preamble of the easement for 423 Bloomfield Avenue business purposes. And it limits the use of the easement area specifically to business, to the grantees, meaning the owners of 423 Bloomfield Avenue, their customers, their business invitees, their successors and assigns. What it does not permit and what it does not reference is residential use or tenants, which I think we've discussed. While it is the current intent of the owner to utilize the residential addition as their primary residence, there's nothing that's going to prevent the future use of that, and most likely will become a rental use with tenants. And the easement does not permit that type of use through the easement area. The layout of the building, of course, there has to be two means of ingress and egress out of the building. There is obviously an enter and exit on the Bloomfield Avenue side of the building, but as the testimony showed and the drawings lay out, it is the intent for the residential use to use that back doorway to come in and out of the building. Otherwise, they'd have to go through the internal first floor of the building through the existing commercial space to get out to Bloomfield Avenue. That's not what the testimony said is going to happen. The intent is to use the rear exit and enter. In addition, that second commercial space in the back is also going to be coming in and out of that rear doorway, in addition to all of the garbage and refuse for every tenant in the building, which is going to be in the basement area right adjacent to that exit doorway. And per the testimony, the garbage is going to be coming in and out of that same area through the easement area. We submit that none of that is permitted by the easement. We submit that this, in fact, is for the broader purpose of not contemplating or permitting the type of residential addition that is being proposed here in totality. And while Mr. Rose is correct in his memorandum, and I think he referenced early on in the meeting that the attorneys, even Mr. Trembulac and I agree, it is not this board's place to opine on easement rights, other than to acknowledge perhaps that there is a dispute over what the applicant has, what rights the applicant has to use that easement area. Therefore, we would submit, my client would submit that, one, he thinks the application should be denied, but if you were to act favorably, it should be conditioned upon either an agreement between the two owners as to the use of that easement area, or that the applicant will have to seek a judicial determination as to their use of that easement area for the proposed addition and improvement. Because we submit, for the reasons I've summarized, the use of that easement area in ways that are not permitted by the easement, in our view, are actually necessary conditions to the success of this entire application. Without the use of that easement area, don't have the second means of egress and ingress, and we submit they can't use in that fashion that they're proposing. So again, while we primarily object and seek the denial of the application, if it were to be approved, it should be conditioned upon either an agreement between the parties on the use of that area and or a judicial adjudication and determination on the applicant's right to use that easement area as they're proposing. And that's all I have.
All right, thank you. Anyone else?
Let's see, going back to Mr. Daniel Garcia Pedroza. I've unmuted you if you have any comments, or if you can write them in. You have a comment. You said.
Yes. Ms. Talley, can you hear me?
Yes, now I can hear you.
Okay, thank you. I'm Daniel Garcia Pedrosa. I'm a property owner across the street, across Glenridge Avenue, and I'm here to speak in support of the application. I think it's an attractive project. It's very appropriate for the area, and it'll be an enhancement to the block. And I think Mr. Kennedy could have come here and claimed hardship and asked for no parking at all, or he could have proposed a 6-story building, or he could have built right up to the property line and blocked his neighbor's windows. But he didn't do any of those things. He's coming with a very modest and reasonable application, and he has a smart solution about parking. So as a neighbor, I appreciate that, and I think anybody with a stake in our downtown should encourage it. Thank you.
Okay.
Right, thank you.
Janice, I have a question. Are we allowed to ask some of the people who commented a question, specifically Mr. Goulden?
That's typically not the process of people unless they bring up something that is, I guess, a topic of discussion, a major issue. You know, it's very hard to rule it out because we have done it in the past, Carmel, but we don't make a habit of it. If there's something that you would like to ask Mr. Golden that will help you sort something out in your mind, then why don't you go ahead and do it?
Yeah, in my view, from what he said, he hasn't really pointed out any reason why this easement to allow people to enter and exit from the back as residents of this proposed construction is problematic. I don't understand. I mean, I can envision some reasons why he would want to, you know, restrict that, but I don't see that he's pointed out any reasons why it's particularly problematic to his property.
Well, I think what he said is that the access is not permitted by the.
No, I understand that.
They don't have the right to do it, and that's enough.
Right. Okay.
Well, that is the answer, and I would buttress that with not only does my client own that property and have the legal right to enforce the rights he has under that limited easement agreement, but that agreement requires my client to maintain the easement area. But that agreement allows my client to park the cars for the use of his building. And with trash and increased traffic, foot traffic, and a sign now being proposed to direct people through that entranceway is going to create issues with the parkers. It's going to create issues with the maintenance of the area. So I would add that to the list of just simply my client's right to enforce the agreement that he's a party to with respect to the property he owns.
Okay. Moving on, Mr. Rustino, Mark Rustino, I have you tried to unmute you. Do you have your audio turned on? Do you want to make a comment, or do you want me to read what you have written? I see that you wrote, for the record, we do use the easement area when it's rainy or when it's snowing to get through to the entrance to our apartment. Mr. Rustino is the existing tenant in the building. I see we have Michael Martinez. I was unable to get an audio connection with Mr. Martinez. Can you hear me, Mr. Martinez? Okay. I think that's it.
All right, Mr. Tremulek.
Mr. Martinez said yes. He typed something. Do you want to?
Yeah.
Mr. Martinez, do you want to type your comment? Okay, he says Mr. Martinez is the owner of 417 Bloomfield Avenue. Okay, if you type your comment, I can read it into the record. He says, Mr. Martinez says, 423 have been my neighbors for the past 16 years. Just have to be patient. I'll get the rest of his comments.
Okay.
Slowly. He says they have been exceptional neighbors.
There's more coming?
I can't tell. I don't get those little dots. That means he's typing. But I think it's a positive. I think it's a supportive comment. So.
Okay.
I'll let you know if I see something else.
All right. That's okay. So, Mr. Tremulak?
Okay, thank you, Mr. Chairman, and the members of the board. Thank you for your time in considering this application. Let me begin by addressing Mr. Golden's comments regarding the easement. First of all, we strenuously disagree with his suggestion that the proposed use of this property, adding an additional apartment, is not permitted by the easement agreement itself. I should point out that the easement agreement refers to the grantees, states that they are about to be the owners of the property at 423 Bloomfield Avenue. So at the time they signed this, they didn't own the property. They certainly couldn't have conducted any business at the property. And how do we know what the, quote, grantee's business purpose, close quote, was, or what the quote business was? I believe, based upon my review of the document, that the grantee's business purpose was to own this property as an investment and to lease it to other parties. if the intention of the easement agreement is to restrict the use of the building to a business use or a particular business use, it would have been very easy to spell that out and say so, and not leave it for people like us to interpret what the meaning was. Furthermore, throughout the agreement, when they're referring to the people authorized to utilize the easement area, the agreement consistently refers to successors and assigns, meaning that this would apply to future owners and future occupants of the building with no restriction whatsoever. Certainly, future successors and assigns of this property would not be engaging in the same business as the grantees were who signed this agreement in 1994. So I can go on and talk and give you other arguments interpreting the easement the way we think it should be interpreted. However, the point is, and this is what your attorney said in his memorandum, that's not for this board to interpret a legal document. It's not within the jurisdiction of this board. It's not something this board is legally allowed to do. And I think everyone agrees that whatever rights are created by virtue of this easement, or whatever restrictions are created by the easement, are unaffected by anything this board does. And it's an agreement, a legal document that the applicant has the right, that the adjacent property owner has the right to enforce, and that enforcement should take place before the Superior Court of New Jersey, not before this body. And I think that's the interpretation in Mr. Rose's memorandum. The only other thing I would say is, I don't believe it should be the applicant's burden, because this objecting property owner, who for whatever reason doesn't think this project is good for the community and good for his property next door, if he believes that this violates the easement, he should have the obligation, like anyone else, to go to court and seek to enforce it. I don't think it's appropriate to put that burden on the applicant and make that a condition of the approval. I think that's all I need to want to say about the easement. Now, turning to the substance of the application, obviously, we are seeking site plan approval for this building expansion. 3 variances for the sign, the rear yard setback, which is an existing nonconformity. I think those are simple and straightforward, and not the subject of any significant controversy. And of course, the parking variance is at the crux of this application. And I'll address that in a couple of minutes, but I just want to first just briefly talk about the site plan. I think you can see from the testimony we presented this evening, the applicant has revised the plans to address all the concerns that the board raised during the September meeting, and also to address the concerns expressed by Mr. Golden on behalf of his client. I think the plans originally were prepared with sensitivity to the adjacent building and to the neighbor, particularly with respect to the window locations on the upper floor. We originally proposed to, not build up to the property line, which we candidly would have the right to do in the central business district where 0 setback is permitted. But we've shown sensitivity to the neighbor with the initial plans, and then the plans have been revised to further step back the addition so as not to interfere, or to interfere as little as possible with light, air, and the views from the windows on the neighboring property. In addition, these plans have gone through several revisions before we even got before this board to address and to satisfy the concerns regarding aesthetics and visual impacts of the project expressed by both the Historic Preservation Commission as well as the board's architectural consultant, Barton Ross. And I think these plans have been approved by the commission as well as Mr. Ross. So I don't think there's any real issues relating to the site plan itself. So let me discuss the parking variance. There's no question that because we're adding this apartment, that we're required to provide 2 parking spaces. There's clearly no space on site to provide any parking, therefore we need a parking deficiency variance for 2 spaces. I'm going to focus my comments on section C2 of the statute rather than C1, which Mr. Sionis referred to. First of all, and of course, C2, as you know, weighs the benefits versus the detriments, and the variance would be justified where the benefits of granting the variance outweigh the detriments, and there is no significant detriments. So clearly, I think public benefit here is that you have a longtime property owner in the central business district who intends to spend a substantial amount of money to improve his building, especially the rear facade, which is very visible to the public on the Glenridge Avenue side, and which is currently rather unattractive, consisting of a worn stucco look. The plan is to replace this existing rundown facade with a new modern facade, which will be visually attractive, much cleaner looking, and I think most importantly, will complement the design of the new parking deck to be constructed immediately next door. So I think the public benefit here, the public interest, is improvement of property in the central business district, and I think that's a goal and objective that the community should encourage, and the planning board should also encourage investment in older properties in the downtown. And I also should point out that the purpose of this addition is to provide a home for Mr. and Mrs. Kennedy as they age and no longer need a single family house. But like a lot of us aging Montclairians, myself included, the options in town are not that great. They're, for people who have lived in town for a long time want to downsize, but downsize into what? There aren't a lot of options available. And I think here you've got, longtime residents, longtime property owners who are seeking to invest a lot of money to provide a nice living space for themselves in the downtown area. And, those are objectives and benefits that inure not only to them certainly, but also to the community at large. The other benefit here is that we're seeking to take advantage of existing parking resources in the downtown and to essentially share parking. And shared parking is a significant theme that runs throughout the master plan recently adopted by the board several years ago. And I think it's one of the goals and objectives of that plan. And if you could indulge me for just a few minutes, I'd like to just read a couple of sections from the master plan that deal with shared parking. First of all, and this is on page 28, this is the land use element in unified circulation plan. Page 28, quote, in many areas, private sector building additions and renovations are constrained by parking requirements that do not sufficiently provide a full menu of modal choices for residents and visitors. Goes on to talk about parking ratios are generally used for suburban areas with minimal transit services and heavily segregated land uses, 2 conditions not found in many areas of Montclair. Furthermore, there are no provisions to allow for shared parking for mixed-use buildings, development, or districts. And then on page 34, the following section appears. Quote, the township should develop shared parking allowances to maximize existing and future parking supply within the business districts. Shared parking is a system where parking spaces are shared by at least 2 different users, allowing for spaces to be used more efficiently. Shared parking strategies are often best applied in business districts that have a mix of land uses. And finally, on page 36, the following appears, quote, parking requirements should be evaluated near Bay Street Station and along the Bloomfield Avenue corridor. Changes to be considered should include allowed for shared parking on mixed-use development sites, allowing for shared parking agreements between neighboring property owners. This measure would greatly reduce the amount of parking supply needed, which will reduce the cost of development and contribute to a more pedestrian-friendly environment. So as I said, what we're proposing is to not burden public parking resources, but rather to take advantage of existing parking, not provide more pavement and less green space, but to utilize the parking that is available downtown, whether it be in these nearby lots owned by Montclair Parking or other private properties. The parking is available, and we're only talking about 2 cars. And we're talking about the persons who have the greatest interest in making sure they can park their cars are the people who are going to be living in this building. So, you know, I think we're trying to do exactly what the master plan encourages us to do, which is to utilize existing parking facilities in the downtown. So those are the benefits. Now, with respect to the negative criteria for granting the variance, in my mind, there is none. The applicant has committed to obtain and maintain these 2 spaces in private parking facilities. Even though we have the right, like everyone else, to use public parking facilities, we're committed to obtain and park vehicles in private lots. Therefore, there's no detriment in my mind, no substantial detriment to the public or any detriment to adjacent property owners. And I think Mr. Anawali actually made the comment at the last meeting, you know, which was basically, whose risk is it if we can't, you know, provide the parking? And I think it's the applicant's risk, who's investing a lot of money to improve this building and is going to need to provide parking currently for himself and his wife, but down the road, whoever buys the building is not going to buy it, or no one's going to rent the building unless they're able to park however many vehicles they have, and they would have to find a location to do that. You know, I think when you balance the benefits to be achieved by granting this ordinance versus the detriments, which are really none or insubstantial in my opinion, that I think we've established an appropriate case for granting the parking variance to allow this very nice project to improve, to go forward and to improve a building that in the central business district that is in much need of improvement. So for all those reasons, I would ask that the board grant site plan approval as well as the variances we've requested. And thank you again for your time.
Hey, Mr. Tremula, thank you. Members of the board, discussion. What say you?
I've got a few questions for discussion if no one else wants to jump in. Maybe this question really is for Mr. Rose or Chair Nguyen. You know, we've heard that we're not to, as a board, evaluate this legal agreement, this easement, and rather to defer it elsewhere. So my question really is, so what if there's no agreement reached between the two property owners? Say the board looks favorably upon the application, and there's a condition that, the agreement needs to be reached or a court needs to adjudicate the matter. What happens if either there's no agreement or judicial interpretation concludes that the easement cannot be used for this new development? Where does that leave the applicant?
It actually leaves the applicant with having spent a whole lot of money and not being able to go forward with the project.
Right.
It's not a, it's a one or the other. It's either an agreement or a court order saying that the easement permits or doesn't permit X, Y, and Z.
So then, just to be very clear, if the court decides that they cannot use the easement for the new development, they cannot then build the new development.
Right, because our condition, our condition would be that they would have to be able to use the easement in order to do the construction, because if you read the terms of the easement, it talks about various components, about construction, changing and access, egress, that sort of thing. And, the specific question would speak to whether or not, and what the judge would be ruling on. The specific question to the judge would be whether or not this easement does or does not allow this revision to the property to exist.
Okay, it's good to understand. The other question I had, I guess, for discussion is, does a granting of this variance for parking, does that impair the intent of the zone plan and the zoning ordinance? And that was, something I raised a little bit earlier, where, we talk about 6-story buildings don't exist along Bloomfield Avenue because nobody can park them. Well, most of the properties, I would say, are somewhat landlocked in some way, maybe not necessarily as this property is, but a lot of them have very similar characteristics to this property. And so it would just seem, to me that, any other property owner, applicant, developer could go out and buy 30 parking spaces in a private lot in perpetuity and build that 6-story building. And to me, that's why I assume or how I would interpret impairing the intent of, zoning ordinance that say you need to provide parking for, your building. I don't know if that's the legal interpretation. I'd be curious to, hear again from others on the board, but, that's kind of how I look at it.
Well, I can say something. That's why there's variances. And it's, and in this case, I'll just give my comments here. I think this is exactly the type of development that should be encouraged in Montclair. People have complained about some of the mega buildings that have come in. This is one unit being constructed. This is an owner who's building one apartment in downtown. This is exactly what should be done. It's a great design. And with respect to the easements, I say we act on this, either accept it or deny it. And we don't have to worry about the easement. They can deal with it themselves. Maybe a little money will do it, or, whatever. Neighbors should get along, right? So we'll figure it out. Yeah, because, but I just think this is exactly what the downtown is going to need, especially in the next 5 years.
Can I add to that?
Sure, Carmel.
Should I go? I agree 100% with Tony. I think this is a really great project. I think the design is very nice. I think that these are long-term business owners who want to stay in town, age in place. I think Mr. Trembulac made a convincing argument. And yeah, this is just a really handsome project. And I hope the neighbors can work it out. It's really disappointing when you think that this is becoming an issue between two neighbors. It really shouldn't be, in my mind. It's a simple little area of space. Why not allow people just to walk there to get into their back door? Anyway, but that's not the subject of this discussion, really. I like the project and I would wholeheartedly support it.
Keith, did you have more to say?
Yeah, it's just, what was the other thing? Oh, I to that point about the easement, I would disagree with Mr. Trembulac. I would put the onus on the applicant to seek an agreement with the adjoining property owner or go to the court. I feel like the applicant's the one that's bringing this up and kind of forcing the issue, and it should be on them to, as a condition of approval, to pursue those avenues. And that was all I had.
Anyone else?
And I have, I'm a little unclear. So if the parking arrangement with the Montclair Parking Company, if they sell their parking lot, or they might even sell their parking lot before this building's even built. You know, I'm sure this building won't be built for another year or so. So then the owners of the Kennedys, what is their recourse? Is to park on the street? Or to buy
I think the answer to your question, Robin, would depend on whether or not we have conditions, what those conditions say. You know, we have the possibility of having conditions that would create a deed restriction that would require that in the event that the parking authority is no longer available, that they find another private or public source to park their cars. Personally, I don't have a problem with them using public if public is available. And then the question always is, do we have enough public that's available? And that's the big question that we don't have an answer for at this point. And, you know, we are endeavoring to pin that down. But in the meantime, we have applications that we've got to decide. So, you know, there are some recourses for us, and as was pointed out in the discussion earlier, ultimately we could revoke a certificate of occupancy through some mechanism. I don't think the planning board has ever done that, nor do I think that the planning board would. We would look for another way to try and accommodate, unless there was a drastic change in the town. You know, again, that's why I was wanting to ask all the questions about what we could possibly do.
Yep.
You know, and I'll just, you know, use this as a way to state my own personal view on this, is that I agree. I think the building looks great with the adjustments and everything. I think the rendering, particularly the rendering of the building next to the completed parking garage, looks very nice. We'll spruce up that little corner of the world very nicely. What concerns me is what Keith was talking about, you know, because, you know, in a way, the hardship is self-created. And if they didn't want to expand the building, there wouldn't be a hardship. And there's nothing that says that it has to be expanded in order to be successful. But by the same token, this is a minimum impact project in terms of the scope of the expansion. It's adding an extra unit that's, you know, making a big difference to the property. So it causes me a lot of conflicting opinions about it. At the end of the day, my inclination would lean more towards supporting it as opposed to voting against it. But we have to really start looking at, I feel we have to, as a board, have to start looking at these requests for these parking variances very closely, because where do you draw the line? Is would 2 units be too much? Would 3 units be too much? Would 6 units be too much? You know, 1 unit isn't so big of a problem if it were by itself. But if you add one unit to every building up and down the street, then you have another completely different ball of wax. So, but that's our job, and that's what we're supposed to be doing, is listening to this and trying to take everything into consideration in making a determination. I think with respect to this particular property, with several conditions on it, I could support it. If the two properties next door wanted to do the same thing, I don't know. We look at each application on an individual basis, and we should be looking at these a lot more closer going forward. So, anybody else have any comments? Want to be heard?
Mr. Chairman, I'll add, I appreciate your comments at the end there. Looking at this, I'll just note that certainly on the other side of this, which, when people talk about, what is allowed and what isn't, I think it's rightfully noted. I think the attorney for the applicant noted that it could build a 6-story, could do this, could do that. That is true, as long as you could build parking along with that is the other side of it. And to just look at half of an equation, we all know is on education side, it doesn't work that way. You have to look at the full equation to see if it works or it doesn't. In this case, it's asked for variances, but note that you could do a bunch of other things. Well, you can't do them without fulfilling what you're supposed to. The challenge around it, I don't think there's still a debate on it. Right now, there is, as I noted before, there is a 22-month waiting period for parking. We are in the middle of a pandemic, and people still have not given up those parking spaces, by the way, because of the fact that they know that others are waiting to jump on those spots. And I think, as was noted by another board member, the policing of this, whatever, the letter is that is even night when there is a car parking lot or somebody applies for a permit or does whatever else, there is no way that park authority or police are going to say, oh, well, this vehicle was from this property that has a specific agreement that's supposed to be parked in Verona and Ubering to get their car in the morning, right? That is not how it's going to work. It will be some other board left facing it. It'll be some other council, but I can tell you that council will be hearing, like we do all the time, the biggest problem in Montclair is parking, not being able to get parking in downtown. The challenges around parking. And it only happens because if you keep allowing one after the next around an ordinance that specifically says you've got to build parking for whatever it is you're doing, we just exacerbate the problem. So certainly, looking at it and looking at all the components, I think everyone has made some great points about what should be, what restrictions should be in place. But the bottom line at the end of the day is around parking. And I think that if we were to ask residents in Montclair, there's going to be a building with some modifications that's going to enable that building owner to make more money over time. Are you going to be really excited about that? It'll look a little different, it'll look a little nicer. But by the way, parking is going to be 2 spots harder in downtown Montclair. I pretty much know how that poll would turn out if I asked the residents. So at the end of the day, it's something to consider. It's a different perspective for sure. But it's a challenge, I think, as we move forward, in that we just see right now there is not enough parking right now, and this will only exacerbate that problem. But thank you.
I think you have to look at parking in terms of a short-term demand issue and a long-term overnight. I think they're 2 separate things. The type of parking that this building will replace is that long-term. That is different than people needing parking to go to dinner. I just think you have to look at it that way. Yes, there is a parking issue.
The long-term wait is currently 22 months.
To go to dinner?
The long-term wait, to your point, is 22 months.
Okay, but these folks are going to rent it privately.
Right, and my point is the enforcement of that, right? So to say a parking enforcement, a police officer, or anyone else seeing a vehicle or somebody applying for a permit for any of these lots that have 22 months are not going to be able to, as they're approved one-off or anything else with specific restrictions around letters, be able to say, this permit that I just received an application for is from a property that has a special letter that says they're supposed to park in Verona and take an Uber. That is not going to be something enforced by a future board or council. That's the challenge around it from a functional, practical perspective.
Here's another angle. If a lot of the larger lots, when buildings that are in this zone need parking, you can't build all that parking in structured parking on small lots. So what happens is these lots get consolidated, 6 or 7 of these things come together, and then we have, the big mega buildings, which people generally don't like. So I think that if Montclair wants to preserve the character of downtown by allowing modest development of existing structures, I think that is a way to encourage kind of sensible small scale development and keep Montclair downtown as a series of small buildings as well. So that's another reason why this kind of helps the parking situation.
So I'm not sure if I'm following your logic of then the mega buildings with ample parking you're saying help.
Well, the mega buildings are constructed with lower parking ratios than are required, than this building is required. They've been one space per unit, even with 2 bedrooms. So I think that we have relaxed parking, and we've indicated that there's shared uses. There's a bunch of kind of rules that are in place for the larger buildings. My point is that, I've heard lots of comments about how Montclair is being taken over by mega buildings. Encouraging development like this is a way to preserve this particular building to not be joined with those 4 that we see in the picture there, then having these 4 demolished so that structured parking could be built and a 6-story building can properly be constructed.
Again, I guess our perspectives, I don't see that as a likely scenario, but I do see, again, right now, not hypothetically what could happen, parking shortages and people complaining about it.
And I think that to Tony's point about, shared parking and, different uses, I think that's what makes this application a little bit different than some of the other ones that we've heard in my mind, is that we've heard no testimony on shared parking. We've heard no testimony about somebody wanting to use the bus or the train to get to work. And I think, for some other applications, that has been a strong point for them in having less parking or proposing less parking. But we didn't hear that, in this application. We heard, we've got cars, we want to park cars, we're going to park cars in a private lot. And I think that's where this application is different in my mind than some of the other ones that we've heard.
Anybody else want to be heard?
Yes. Can you hear me?
Yes.
Yeah, so would just add that somewhat building off of what has been said, we certainly want the applicants to be able to age in Montclair, but the balance here, of course, is not occurring in a way where it comes at the cost of others being able to do so. And I think my concern is this may go on to, as we discussed, some other individuals that are willing to drive around longer, park further away, deal more with the burden of parking, or even just make the cost analysis they're not willing to continue with the private parking. I know we can work on that from a condition, but as Mayor Spiller noted, this does exacerbate the current condition with regard to parking downtown. So I think it is, and the one other thing I'd add as well, the one challenge here also is that we have granted variances that are rather large when it comes to parking. So kind of going back to my initial point with this particular case, it's a little tough to push so hard on a particular applicant. So for me, that's why, I've even voiced in my comments just now, there's a little ambivalence in my mind in terms of exactly where to go with this. And I think kind of to your point, Chair, when it comes down to the conditions and exactly what we have in place to ensure that, the parking situation is handled as best as possible while still enabling, a nice, appropriately sized building to, or project to go where this is. And also to Carmel and Tony's point, having individuals use spaces in this way does encourage the view, look, feel, even experience of Montclair that is consistent even with the master plan. Actually having people that are downtown, not always driving in and parking and going away, et cetera. So I do think this is actually a bit more complex than people may see it at face value. And again, I think it does come down to the conditions if we could go ahead and discuss those once everyone else has a chance to comment.
Carmel.
I just, I guess I don't understand why we're having such a tough time knowing what the availability is for parking spots in our lots. We've asked the question about Orange Road parking lot. We've asked the question about this new proposed lot for the Midtown lot. Why can't we get an answer as to what are the commitments that are already in place for those lots so that we can have a feel as a planning board who has to see these questions come to us over and over and over again about parking variances, understand what the availability of parking is.
Yeah, I'll go with that too, because there's no data for us to look at. Absolutely.
Exactly, yeah. And it's come up for years. It's come up for years. And is it because are the projects that are approved, are the tenant changing so that they, require more parking or less parking? What's going on? It's just a puzzle to me, and yet it's a crucial part of the decisions that we have to make.
Yeah, two things I would add to that. So there's a timing dimension here as well, where there's a lot of approved projects that haven't been fully realized and fully accessed. Also, again, not to be highlighting this particular feature, but having had children that are part of different, preschool schools within Montclair, I myself have had years where parking is absolutely horrendous. The next year, it's not so bad. It's terrible the following year. And it's largely because my customs and use of downtown Montclair have shifted a bit, the times that I'm there and what I'm accessing. So I do think there's some diversity in terms of limits around access to parking. And again, there's serious, deep concerns. They're not just anecdotal across hundreds of, thousands of individuals parking, but I think it's very varied in terms of people's experience parking downtown. But that's just my own 2 cents with this. And there's no data, actual data.
Anyone else?
Yeah, this is Steve. I don't have any problems with this design. With a neighbor coming up next door and effectively building a wall so you can't get in and out of the back of the building, that's something that they'll have to deal with. Obviously, you could do some internal design to make access from the front. The problem with parking is a problem throughout all these towns in New Jersey. One way that you can mitigate that is just raise the price for it, and you'll have less of a demand. Seems to work in other places, but I'm for this project.
And to Steve's point, I think it also is an issue of equity to a degree as well, because you do raise the price and certain people can afford, no matter, there's a limit for everyone, but the limit is much higher for some folks, but it also, greatly limits the ability of others to access that parking then. So it certainly is a solution, but a solution that still has some consequences of its own.
Hey, on that note, you got to look at those overnight parking fees as a landlord subsidy, because an apartment's going to go for so much money. And if someone can rent that apartment and get a $50 space, they'll give the landlord more money. The landlord's going to grab whatever they're going to grab. If it's $150, the landlord will get less.
Tony, just to take this as far as you're going with it, what's the application to this application? Or because I think.
Well, I was just commenting on Steve's comment about price. I mean, I think you have to look at like all those public lots that were taken away for the Wellmont project. It's pretty cheap parking, and a lot of the buildings that are around there, the landlords are able to capitalize on that cheap parking and rent the buildings out easily. So what I'm saying is that there's a market. People will pay so much for parking and an apartment. And if you raise the price of the parking, the landlord will probably get less money. So all I'm saying is that, you know, this equity in parking is a landlord subsidy. That's one way to look at it.
Yes, even with this, though, even the inconvenience, even if you didn't have private, there's a premium still in time or inconvenience, et cetera, or just deciding not to have a car that is reflected also in, you know, implications to the landlord. So yeah, so I see what you mean. The one thing though with affordable housing is if you have an affordable unit in an area that's extremely expensive for parking, that becomes an issue of its own as well. So whenever people look at kind of markets and pricing as a solution, I sometimes squint a bit just to see what the real impact will be to those that are a little more economically vulnerable. But I certainly understand the case here.
Just going to note, as some people are asking and talking about numbers, for the purposes of any development or anything else, I think that this board should look at the fact that there are 0 spaces available in public lots to use for any type of development project. So if that's the number people are looking for, again, currently, we have hundreds of people waiting for spaces. The new lot that's being built, I'll note with cost to taxpayers as well, is going to be 315 new spaces, as I noted last time. Again, it is up to the council to determine how many of those will be metered spaces or others, depending on what the dynamic and breakdown should be. But even if it's conservatively moved to 70% of those for permit spaces, again, we would still have about 129 people on the waiting list for permits. So what's the additional space that's available? The answer is none, right? There's no space available in the lots.
So is anyone inclined to make a motion one way or the other?
Well, Keith was talking about some conditions. So before there's a motion to approve or deny, should we talk about what the conditions might be that everyone is considering?
Well, if you're talking about making a motion to approve, yeah, conditions would make sense.
Yeah.
If you're denying, there wouldn't be conditions associated with the denial.
I guess one of the conditions that was talked about was the security of having these 2 parking spaces in perpetuity with the building. Is that kind of what I heard?
Well, something that would allow some recourse, yeah. I mean, that's the idea if we're talking about these spots being in non-public locations, then the Montclair Parking Authority is not, I wouldn't characterize it as the most, secure, long-lasting. It's going to be there until they find some use for those spaces in those parking lots, and then it's going away.
Okay, so the owner is indicating that, for example, Mayor Spiller was talking about no parking. I'm assuming no parking is in municipal controlled lots. So the condition would be that these owners would not rent in municipal lots, but any other lot open to the public would be fair game. Is that what you're thinking about?
That's what we discussed last.
So as not to strain the, further strain the 22-month waiting period.
Exactly.
Do you want a motion?
Well, we need a motion to prove this one way or the other.
Yeah, all right, so I have a terrible backache, I'm sorry. So I make a motion to approve this application subject to conditions that we'll discuss.
Well, what conditions would you associate?
We talked about making sure that the 2 parking spots are obtained through private, through a private lot, not in municipal lots. And we talked about the screening for the second floor roof deck. And I think those were the 2 conditions we had. And then, of course, the easement is something else. So
Deed restrictions for parking? Deed restriction? Associating the parking requirement with the deed restriction? Tying it to?
Deed restriction, yeah. They seem open to that, so why not? That's the most strictest measure.
Other potential conditions, Daniel?
Sorry, I may have missed, so it would be a deed restriction regarding paying for private parking for those?
I think that would be one way that we could, add some teeth to it.
Yeah, because it was mainly that and the easement in my mind as well. So I think if we have those as conditions, and then if Carmel added anything else, but that should be fine.
And
if anyone has anything else.
The easement, as proposed in the board attorney's memo, where the applicant either has to come to an agreement with the property owner, adjacent property owner, or has to bring it to court to litigate it to a determination.
They have to satisfy the easement condition.
Right, but that's a condition.
Yeah, I thought that was out of our purview.
Well, that's why if go back in the very end of the memo, for Mr. Rose, that last line, we can't make a determination, but we can make it that they
then include that.
Get a determination. We're not determining it, but we're forcing them to get a determination.
Yeah. Mm-hmm.
Anything else besides our standard conditions?
That sounds good to me. They have to pay the development fee for the affordable housing.
Yeah, that's a standard.
Just want to make sure it's in there.
So Tony, is this your motion or is this your motion?
Carmel's. I'll second it though.
Okay.
And as a question on that, does that include, I know it was mentioned by the attorney for the project here, does that include a yearly verification? I know, Mr. Chairman, you noted that too. What is that? I said it's deed restricted. What does that include in terms of verification? Thinking through the lens of the parking utility or others in terms of, having to enforce. What is the enforcement mechanism or proof mechanism?
Well, yearly certification certainly gives them an obligation to report, but where would that certification go? Janice?
It would go to me. I don't think that would go to the parking authority because it would be private parking.
So it would come to you and so that you could refer it if for some reason it didn't come in or something like that.
Right.
Is that something that your office can accommodate, that deals with?
We do, yep.
Okay.
Just a question. Should we put in the conditions that if the parking condition is not met, then the property will be subject to the withdrawal of a certificate of occupancy?
I don't think that that's exactly a condition. That's an operation that the town can use to enforce the condition.
But we don't put that in our resolution or no.
Yeah, I don't think that would be appropriate, something that they could stipulate to.
Mm-hmm.
It's already in our ordinances that it will be revoked if they violate their site plan approval.
Right, exactly. If you don't meet a condition of approval, then you're subject to have your approval revoked.
Okay.
Okay, so this requirement to rent the parking spaces, so the owners have to rent the parking spaces even if they have no cars? Just asking.
I think we have to have the condition there, and then let them seek relief from it if they decide that they don't have cars.
Right. Okay.
Because,
So that's
you know,
true, they don't have cars.
that
Yeah.
could be transitory,
Yeah.
you know? So they might, and if they're doing it on a yearly basis, you know, it's something that they could get, you know, an exemption on maybe, but I wouldn't build that into the, I wouldn't build that as an exception to the condition.
That's good.
Chairman, just so I understand, I thought the condition would be worded such that there's proof of access to a private garage for any cars owned or driven by the current occupants or something like that. So wouldn't that address Tony's point anyhow, or is there something I'm missing with the way we would word this?
They have to have 2 spaces. So we have to, the ordinance requires 2 spaces. So that's what we're trying to get compliance with, the 2 spaces.
Right, right. Just as if they had the 2 spaces and they were left empty behind or wherever the spaces were. If they were provided on site as they should, according to.
They have to provide, they're supposed to provide on-site spaces regardless of whether they're used or not.
Yeah, exactly. And and even if no one's using those on-site spaces, they would be provided anyhow. So,
right.
Okay.
So the spaces, in fact, would be opportunities for shared parking with other buildings, but that's doesn't apply here.
Yeah.
So.
Right. Okay.
Okay, we have a motion and a second, and I'll call the roll. Chair Nguyen?
Yes.
Vice Chair Brodock?
No.
Mayor Spiller?
No.
Counselor Schlager?
No.
Ms. Willis?
Janice, you have to unmute her.
Carol?
I'm trying to unmute. Did you hear me?
I can hear you now.
Okay. I missed the last meeting. I don't think I can vote on it tonight.
Mr. Rooney?
Yes.
Mr. Ian Wally?
Yes.
Ms. Lockman?
Yes.
And Mr. Gilmore? Mr. Gilmore?
Oh.
I unmuted you.
Yes.
Okay, so we have 4 in favor and 3 opposed. Oh, 5 in favor, I'm sorry. And 3 opposed. So it carries. Resolution carries.
All right, Mr. Tremulak. Next stop, working out something with that easement. Can't hear you.
I unmuted you, Alan.
I said we'll get to work on that right away.
All right. Well, good luck, gentlemen.
Thank you very much. And good night.
Oh, good night. All right. And let's see. Next on our agenda are subcommittee appointments. Do we have anything on that, Janice?
Yeah, I included the list in the packet. It should have been in your packet. What I need is another member on the revisions committee. Right now, it's just John and Steve.
Right, we discussed that last time.
So are there any volunteers?
Yeah, no, I heard that I was gonna say, I'm glad to go ahead and volunteer. I heard the discussion at the last meeting on this, so I think we can wrap that up. The one question I had, Janice, and I probably should ask this initially, you're saying much of this is done remotely via correspondence over email and a few instances where we look at the actual materials in person at 205 Claremont?
Right.
Okay.
It
Yeah,
is.
that sounds great. And yeah, glad to volunteer.
The other open appointment is the redevelopment subcommittee. Right now, that's Carmel and Daniel. I don't know if anybody else wants to sit on the redevelopment subcommittee. Any interest?
I would if no one else wants to.
Okay, Keith, I'll put you down.
I think you'd be good for that, Keith.
Yeah.
Thank you.
Okay, good. All right. And the next item on our agenda is the master plan subcommittee report, which Tony and I worked with Tony and Daniel and John to prepare a draft report that summarized the board's recommendation how to handle the safe plan. The one thing that did come out of my inquiries with NV5 and with New Jersey Department of Transportation to rename the document, not an implementation plan, but a design guideline. And New Jersey Transit said no, because they paid for that document. That's part of their list of documents that they have on their website. And at this point, since it was done in 2017, they said they cannot change the name of it. So
yeah, they won't change the name of it.
Right.
They won't change the name of it, but that doesn't mean that we can't call it whatever we want to.
Right. So the language in the proposed master plan amendment that I sent around today, I apologize for the lateness, but it was resolved last Friday, and I was out of the office. Essentially says that it should be used as a design guide, and we have a draft. What we anticipate doing is putting a resolution in the front of the unified plan. If this is adopted by the board, that clearly that would be the preamble and would clearly indicate how that design guide would be used, in addition to the language that's proposed in the memo that was sent out.
Yeah, Janice, so one thing in the notes, so we went to painstaking efforts to make sure these are options, it's a guide, and so when reviewing, we bolded the words option in a few places
right,
to note the additions having been there, but I don't think we need to keep it bolded in the middle of a paragraph per se. I mean, keep the word there for sure, but that was the only note on the draft that was circulated.
Carol, I just unmuted you in case you have any comments, because I know you have problems controlling your mute. Do you have any comments at this point?
Well, I will have comments, but I'm not going to speak right this minute. I'll hold on, but thank you for unmuting me, but.
Okay. Okay. I'm going to mute you again because we are getting feedback. So in terms of moving ahead, what I would like to do is schedule a time in November to have a public hearing on amending the master plan. I think the second meeting in November, which would be November 23rd, we don't have any applications. And that would be a good time to schedule a public hearing, not only to amend the master plan for the SAFE plan, but also the draft stormwater management plan. I know we've talked about it. I've prepared a draft stormwater management plan that I've submitted to both the master plan subcommittee. I sent it to Keith because that's his area of expertise. I wanted to get his comments. I also sent it to our board engineer and the township engineer so that they all have an opportunity to comment on it. So what I'd like to do is, now that we've got a draft, I can send it out to the board, to the full board, with the anticipation that if you want to go ahead, we can schedule the public hearing for either November 23rd or possibly December 21st, because we don't have any applications right now for either of those meetings.
Okay,
So Janice, when would the board act? I'm sorry.
I need one person at a time.
I'm on it, but when I get my turn.
Okay. Carol, why don't you speak right now since you're unmuted?
Okay, well, the question was just basically, I know that I'm looking at page 3 of the document, and at the end of that first paragraph, there's so many deletions that one can't read what that final sentence is, so at least I can't. So is there some way to decipher what that's supposed to read as? Page 3, the top paragraph, the last sentence?
As indicated above, the design guide can be used as a reference document to help determine an appropriate street treatment where accommodate biking is potentially possible. I think that it probably needs to be cleaned up a little bit.
Yeah, in fact, it's totally illegible in the copy that I'm looking at.
Okay.
And so would you say that again, please?
It says, as indicated above, the design guide can be used as a reference document to help determine an appropriate street treatment where accommodating biking is potentially possible.
I was just writing, that's okay.
Okay, I can send you a cleaner version of that.
Right.
Any other
keyword
comments?
there, I think it's-
Carol, I'm going to mute you again so that we can hear. Are there any other comments?
Yeah, Chair Wayne, keep me honest on this, but I think with that sentence, the one change would be accommodating biking is potentially possible. And the reason this sentence even emerged like this, and there may be a couple others, is we are looking to make sure it's a guide to help determine, appropriate, where accommodating is not just possible, but potentially possible. So, potentially possible guide help determine. We tried to soften the language as much as possible. So yeah, I think that Chair Wynn, keep me honest there, but I think that sentence and others have really tried to soften it as much as possible.
Right, because the idea is that something might be possible, but it's not practical. It's not. It's not the best possibility, and so we want to make sure that we're trying to make sure that the guidelines that were set out by the implementation plan were construed as guidelines and only as guidelines, and that there had to be individual assessments with respect to any implementation to make sure it works on a number of different planes, before something gets implemented.
Janice, this is Tony. What will we be voting on next? It would be the adoption, it would be the master plan amendment, and the preamble, right? The memo?
Well, no, yeah, the master plan amendment is basically what's in that memo. And it would be formatted so it's I'd have a red line version and a clean version in the master plan.
Okay, so then what would a yes vote? Okay, what would a yes vote and a no vote be for at the next meeting? So if someone were to vote yes or no, what does that mean?
Well, it depends on how the motion is formatted, but I assume if the motion is to amend the master plan as indicated, then a yes vote would be to amend it as indicated in the draft plan.
Okay, and then if it's not amended, then no preamble is necessary? So,
right.
Okay, I understand.
The preamble basically memorializes the decision of the board.
Okay, thank you. And then you also said that's public, right? So others would be coming in. Okay, thank you.
Yeah, it'd be a public hearing.
I'm trying to unmute. Did that happen?
You're unmuted, Carol.
Okay, I noticed that throughout you changed the word from manual to guide. Is there a reason for that change of wording?
Yeah, the reason is that we wanted to emphasize again that it was to be looked at as a guide and not as something that had to be strictly adhered to in every last period, comma, and otherwise.
Question was about the change of word manual. I thought manual was perhaps softer than guide in that regard. But you see guide as being more fixed than a manual or less fixed than a manual?
So I see a manual. I see a manual. If I look at an instruction manual, it's like you're supposed to do what it says, you know. And I look at manual as a bit stricter than a guide.
The other way around. For me, it was the other way around, but that's okay. I thought there might have been someone by the attorney's point of view. Thank you.
Are there any other comments?
I think my only other comment was just following up on what Mr. Gilmer had said. There's a couple of strange wordings in there, so just before this goes out for, a final vote, just clean up some of the grammar a little bit.
Okay. We'll work on that. Okay. If there's no other comments, then the last thing on the...
Can you hear me?
Yeah, I can hear you. Is
Sorry,
that Daniel?
Sorry, yes, I might be saying what you're getting to, so sorry, apologies if that's where this is headed, but on the timing, it seems as though November the 9th or 7th is already full.
Yes.
And is it the first week in December, December 7th is already full as well?
I can tell you 65 Church Street will not finish in the next month or two. So the first meeting of the month right now is going to be 65 Church Street. You're right,
yeah. Timing for revisions, et cetera, basically.
Right, so that's why I'm reserving. We have we've been a slowdown in new applications. I have some new applications, but I don't think we're going to be getting to those until January. So it's this opportunity with the second meeting in November and December to really concentrate on the master plan amendments. So that's the timing that I was working with.
Right. We are in the COVID era, so I don't even know how relevant this is, but one of those is 3 days before Thanksgiving. The other is 3 days before Christmas Eve. And so it's, a bit of a challenge on timing. Could we go ahead and say it is November the 23rd, and then just see how the applications proceed to see if December 7th does open up? Because if either 65 Church Street somehow goes smoother than anyone would anticipate, or potentially bumpier, such that it doesn't even, maybe it needs more time than December 7th, this could perhaps land on the 7th. Of course, I know 65 Church Street would take precedent, but
it's just because, again, we can try for that, but practically speaking, right, it's not going to be. It's going to be continued, and you can't really continue an application like that to the meeting that's 2 weeks away, because we meet every 2 weeks. Because that doesn't give them enough time to revise their plans and send them out, have experts. So that's why we have to have a consistent monthly meeting on those big applications. And just November was really tough. Remember, November was really, really tough to schedule because of the council's meeting on Mondays during the month of November and holidays. So maybe we could come up with a special meeting date in December. That might be
even if it was that we went back to back the 7th to the 14th, I think that would still be better than if we did 7th and the 21st.
Right. We could certainly.
And this is an issue that, people come on many different sides of it, but I think there is significant interest for folks that, own businesses, own homes, rent apartments, have kids, are, seeking to age in Montclair. So it's the sort of thing where it may be a challenge. But yeah, so I don't know. Is it thoughts from others though? Maybe it's just me. I think 3 days before Thanksgiving or 3 days before Christmas Eve for something of this importance might be, ill-advised, but thoughts from others?
That's fine with me.
Yeah, it's hard
I
to, it's
think in a
hard to
normal
say.
year, yeah, I'd say, I think in a normal year, I'd agree with you. I think we'd see probably more vacations around Thanksgiving, but this year, I feel like
Yeah.
less people are going to travel.
Right.
Yeah, unless something dramatic happens within the next few weeks. That vaccine is coming out, you know?
Oh, well, yeah, you all know that I work for a company with vested interest in that. But I also do see a lot of people getting antsy to at least have small congregations over Thanksgiving in a way that I find a little bit unsettling, but no less impactful to their ability to attend a hearing or, even virtually attend the Monday before Thanksgiving, even if they're just cooking for their family or buying last minute groceries, et cetera. So, I don't know. If I'm alone in this, let me know, but I would strongly encourage us to push for the first week in November, realizing that is a slim chance. And if that doesn't work, then we reschedule the 21st to the 14th of December and have it on the 14th of December. Sorry, the first week in November, first week in December, and if neither of those come through. So what is that? November 9th, if we can't do the 9th, December 7th, if we can't do the 7th, reschedule December 21st to the December 14th and have it on the 14th. Are folks following, or let me know if it's just me?
Well, I would say that I would agree that probably not a good idea to have it during the week of Thanksgiving. What else we do depends on the schedule, but I would not think Thanksgiving would be the good week to have it.
Right.
So let me get back to you, and I'll look into the possibility of having the special meeting on December 14th for the master plan amendments. Okay?
Yes,
I'd be all right with a special meeting.
For us to have it on the 20th? Is it helpful for us to say it's going on November 23rd while we still know it's likely to move, just so that it still is on the docket and takes precedent in case other things come along, or it's already on your radar, so no need?
It's always already on my radar. I don't think I think let's be realistic. It takes a lot of work to do these meetings. And if I have nothing on the agenda, we'll just, change what we were supposed to hear on the 23rd. We'll just change it to the new date, which would be December 14th. If that works out to be the date. Okay. And then I want to get to this as much as you do. We've been working on these master plan amendments forever, it seems.
Yeah.
Okay.
Great.
All right, that sounds like a plan.
The next item on our agenda is payment of our bills.
Do we have any?
Yep.
Yeah, we've got bills. We have several pages of them. I have no issues or questions on them and would move to approve the bills.
Okay. Second?
I'll second.
All in favor?
Aye.
Aye.
Opposed or abstentions? Okay.
All right. Thank you, Mr. CFO.
Great.
Anytime.
All right. Thank you, everyone, for your participation and your contributions and your patience.
Well, good night.
And have a good evening.
Good night, everyone.
Take care.
Good night.
Bye.
Janice.
Yeah. Oh, I think